26th Amendment itself was passed by Parliament to overcome the effect of this judgment. Now, by this amendment, Article 291 and 362 are omitted. Article 363A is inserted and Clause 22 of Article 366 is amended. Therefore, one cannot be allowed to say that the above said omitted articles and amended clause were the essential part of the constitutional scheme. So, they have to be read only in the context of a challenge made to the presidential order, which sought to render nugatory certain rights guaranteed in the constitution which were then existing. In any event, the constitutional bar of Article 363 denies the jurisdiction of any court in disputes arising from covenants and treaties executed by the rulers. The statement of objection reasons of 26th Amendment clearly points out that the retention of the above articles and continuation of the privileges and privy purses would be incompatible with the egalitarian society assured in the Constitution, and therefore, in order to remove the concept of rulership and terminate the recognition granted to ruler and abolish the privy purses, this amendment was brought. Now, 92 is very important, Lord, which would also assist your Lordship on the question of federal diversity. We are of the opinion that the observations of Justice Shah in Madhav Rao that privileges of rulers are made an integral part of the constitutional scheme and that the institution of rulership is an integral part of the constitutional scheme must be read in their proper context. That was a case whereby a presidential order, the rulers were deprived of their privy purses and other privileges while keeping Article 291 and 362 intact in the Constitution. This doesn't arise here, my lord. Indeed, the said presidential order was issued after the government failed in its attempt to effect an amendment on those lines. It is in that connection that learned judge made the above observations. It is clear that the learned judge used the word integral part in their ordinary connotation, not in lexicographical sense. Ordinarily speaking, integral means of a whole or necessary to completeness of a whole, and as forming a whole. Our Constitution is not a disjoint document. It incorporates a particular socio-economic and political philosophy. It is an integral whole. Every provision of it is an integral part of it. Even the provisions contained in Article 21, temporary, transitional, and Part 21, temporary, transitional, and special provisions. One may ask, which provision, which concept, or which institution in the Constitution is not an integral part of the Constitution? He will not find an answer. To say that a particular provision or a particular institution or concept is an integral part of the Constitution is not to say that it is an essential feature of the Constitution. Both are totally distinct and qualitatively different concepts. The said argument is really born of an attempt to read a judgment as a statute. One may tend to miss the true meaning of the decision by doing so. We may say the aforesaid observations of Justice Shah constituted the shit anchor of the petitioner's argument relating to the basic structure. My lord, just similarly, federalism is also, my lord, a basic structure. But the federal diversity can still exist within federalism. But my lord, that's a separate issue. In the above premise, it is not permissible to test 26th Amendment with reference to observations made in Madhav Rao. But now kindly come to para 96 at page 566. Para 96 at page 566.
Yes.
Permanent retention of the privy purse and the privileges of rights would be incompatible with the sovereign and republic form of government. Such a retention will also be incompatible with the egalitarian form of our Constitution. That is the opinion of the Parliament, which acted to repeal the aforesaid provisions in exercise of its constituent power. The repudiation of the right of privy purse privileges, dignities, etc., by deletion of Article so-and-so, which the recognition of the rulers and payment of privy purse are withdrawn, cannot be said to have offended Article 14 or 19(1)(f), and we do not find any logic in such submission. No principle of justice, either economic, political, or social, is violated by the 26th Amendment. Political justice relates to the principles of right of the people, that is, right to universal suffrage, right to democratic form of government, and right to participation in political affairs. Economic justice is enshrined in Article 39 of the Constitution. Social justice is enshrined in, well, Lordships can skip that. 97. A serious argument has been advanced that the Privy Purse was a just quid pro quo to the rulers of Indian states for surrendering their sovereignty and rights over their territories, and that move for integration began on a positive promising note, but it soon degenerated into a game of maneuver, presumably as a deceptive plan of action. This argument, based on the ground of breaking of solemn pledges and breach of promise, cannot stand much scrutiny. To say that without voluntary accession, India, that is Bharat, would be fundamentally different from that Bharat that came into being prior to the accession is untenable, much less inconceivable. Please mark this, Malad. Beautiful words. One should not lose sight of the fact that neither because of their antipathy towards the rulers nor due to any xenophobia did the Indian government entertain the idea of integration, but because of the will of the people. It was the people of the state who were basically instrumental in integration of India. It would be apposite to refer to the observations of Justice Bose in Virender Singh's judgment. Every vestige of sovereignty was abandoned by the dominion of India and the states and surrendered to the people of the land, who, through their representatives in the Constituent Assembly, hammered out for themselves a new constitution in which all were citizens in a new order, having but one tie and owing but one allegiance, devotion, loyalty, fidelity to the sovereign democratic republic that is India. Thereafter, it is also worthwhile to take note of the historical process of states integration. Lord, your Lordships may directly can come to 109 at page 569. 107. On a deep your Lordship gets me, my Lord. Para 107. On a deep consideration of the entire scheme and content of the Constitution, we do not see any force in the above submission. In the present case, there is no question of change of identity on account of 26th Amendment. The removal of Article 291 and 362 has not made any change in the personality of the Constitution, either in its scheme or in its basic features or in its basic form or its character. But please read 370 in this. Does it change the personality of the character of the Constitution? The question of identity will arise only when there is a change in the form, character, and content of the Constitution. In fact, in the present case, the identity of the Constitution, even on the test proposed by the Council for writ petitioners and interveners, remains the same and unchanged. Sri So-and-so has contended that by removing the real and substantial distinction between erstwhile princes forming a class and the rest of citizenry of India, the constitutional amendment has at one stroke violated the basic structure of the Constitution as reflected both in Article 14 and 51C and treated unequals as equals, thereby giving a go-by to a solemn treaty obligation which was sanctified as independent constitutional guarantee. 109. Malord, this is very, very important and crucial for our purpose, Malord, the purpose of the respondents. After carefully going through the above decisions which relate to service matters, we are afraid that such an argument as one made by Sri So-and-so could not be substantiated on the principles laid down in these two decisions, that Article 14 will be violated if unequals are treated as equals. In our considered opinion, this argument is misconceived and has no relevance to the facts of the present case. Please note this. One of the objectives of the preamble of our Constitution is fraternity, assuring the dignity of the individual and the unity and integrity of the nation. It will be relevant to cite the explanation given by Dr. Ambedkar for words fraternity, explaining that fraternity means a sense of common brotherhood of all citizens. No region, no part of the region, no citizen staying in any region should get any different treatment than rest of the country. In a country like ours, with so many disruptive forces of regionalism, communalism, and linguism, it is necessary to emphasize and re-emphasize that unity and integrity of India can be preserved only by a spirit of brotherhood. India has one common citizenship, and every citizen should feel that he is Indian first, irrespective of other bases. Therefore, I started by saying that a psychological duality in the mind is now completely gone. In this view, any measure, please mark this, in this view, any measure at bringing about equality should be welcome. There is no legitimacy in the argument in favor of continuance of princely privileges, since we have held that abolition of privy purses is not violative of Article 14. It is unnecessary for us to deal with the cases cited, which according to him go to say so and so. In 1110, one of the arguments advanced by Mr. D.D. Thakur is that the Constitution should be read in the context of a pluralistic society of India, where there are several distinct and differing interests brought together and harmonized by the Constitution makers by assuring each section, class and society preservation of certain political, cultural and social features specific to that class or section. By way of example, reference to Article 370, which confers a special status for Jammu and Kashmir, is made. He continues to state that likewise in the northeastern states, the tribals were given autonomous powers for their district councils co-equal to what is conferred on the states, and that the minorities special provisions are made in Article 30. Besides, Article 25 and 26 are meant to safeguard the minorities and religious denominations. The persons to determine the injury will be those for whom these provisions were made and whose interests are prejudiced. According to him, in such a circumstance, the assurance and guarantees given under Article 291 and 362, which are the Magna Carta, assuring the rulers of their pre-existing rights, cannot in any way be destroyed. We do not think that the aforesaid special provisions have any relevance here. As repeatedly pointed out supra, the only question whether there is any change in the basic structure of the Constitution by deleting Article 291 and 362 and by insertion of Article 363A and amendment of Clause 22 of 366. We have already answered this question in the negative, observing that the basic structure of the essential feature of the Constitution is or are in no way changed or altered by the impugned amendment. We cannot make surmises of its ifs and buts and arrive at conclusion that Article 291 and 362 should have been kept intact as special provisions made for minorities in the Constitution. It is but a step in the historical evolution to achieve fraternity and unity of the nation, transcending all regional, linguistic, religious and other diversities, which are the bedrock on which the constitutional fabric has been raised. The distinction between the erstwhile rulers and the citizenry of India has to be put an end to so as to have a common brotherhood. The court traces it to fraternity mentioned in the... Before embarking upon a detailed discussion on the various facets of the contentions, both factual and legal, we shall deal with the precursive point with regard to the pre-constitutional instruments of accession, the merger agreements, and the covenants which guaranteed the payment of privy purses and recognition and personal privileges, etc., and which the agreements ultimately facilitated the integration of these states with dominion of India. Then, my lord, your lordships may skip its history. 31. This accession of Indian states to the dominion of India established a new organic relationship between the states and the government, the significance of which was forging of a constitutional link or relationship between the states and dominion of India. The accession of Indian states to dominion of India was the first phase of the process of fitting them into constitutional structure of India. The second phase involved a process of twofold integration, the consolidation of states into sizable administrative units and their democratization. Though high walls of political isolation had been raised and buttressed to prevent the infiltration of the urge for freedom and democracy into Indian states, with the advent of independence, the popular urge in the states for attaining the same measure of freedom as was enjoyed by the people in the provinces gained momentum and unleashed strong movements for the transfer of power from rulers to the people. On account of various factors working against the machinery for self-sufficient and progressive democratic setup in the smaller states and serious threat of law and order in those states, there was an integration of states, though not in a uniform pattern in all cases. Firstly, it followed the merger of states in the provinces geographically contiguous to them. Secondly, there was a conversion of states into centrally administered areas. And thirdly, the integration of their territories to create a new viable units known as Union of States. My Lord, your Lordships, may, my Lord, now come to para 38, my Lord, at page, my Lord, 554, PDF 554. Now, my Lord, the Honorable Court discusses Madhav Rao, because Madhav Rao obviously was cited. That which said that privy purses are an integral part of the Constitution of India. That is one. And number two, that you could not have taken it away by merely deleting the definition of princes. These were, my Lord, the two. Then 38. On May 14, 1970, the Constitution 24th Amendment Bill for abolition of the above said privy purse, privileges, etc., conferred under Article 291, 362, and 36622 was 366-22 was introduced in Lok Sabha by the then Finance Minister Sri Chavan. The bill contained 3 clauses and a short statement of objects and reasons. The statement reads as under: the concept of rulership with privy purses and special privileges unrelated to any current function and social purposes is incompatible with an egalitarian social order. Government have therefore decided to terminate the privy purses and privileges of rulers of former Indian states. On September 2, the bill was voted upon in Lok Sabha, but on September 5, Rajya Sabha rejected the same since the bill failed in the Rajya Sabha to reach the requisite majority and not less than 2/3 present as required by Article 368 and voting. Close on the heels of the said rejection, the President of India, purporting to exercise his powers under Clause 22 of Article 366 of the Constitution, signed an order withdrawing recognition of all rulers of the country en masse. Look, this was the subject matter in Madhav. A communication to this effect was sent to all rulers in India who had been previously recognized as rulers. So what was done was, by a constitutional order, which is unheard of, my Lord, except in 370, the Honorable President virtually declared 2 provisions to be nullity. The presidential order, para 40, de-recognizing the rulers were questioned in Madhav Rao, Scindia versus Union of India by filing writ petition under Article 32, challenging it as unconstitutional, ultra vires and void. An 11-judge bench of this court, by its judgment dated so-and-so, struck down the presidential order being illegal, ultra vires and inoperative on the ground that it had been made in violation of power of the President of India under Article 366(2) of the Constitution, and declared that writ petitions would be entitled to all their pre-existing rights and privileges, including right to privy purses, as if the impugned orders therein had not been passed. Here, it may be noted that Justice Mittar and Justice Ray gave their dissenting judgment. Thereupon, they started getting privy purses. Lord, kindly come to para 77 at page 562. Rest, my Lord, may not help, my Lord, assist your Lordships, my Lord, either way. 77. According to Mr. Sorab, Para 7.
Just one.
7.
Just one.
Just one.
Your lordships would. I'm sorry, no, my apologies.
In the merger or the other agreements, that the President of India will recognize the ruler or something because of inheritance and otherwise. That was there.
Yeah,
That
but
was
366.
there was some stipulation because those the rule of primary nature and other things were all recognized in that. That's how.
Yes, but every ruler was
You are
apart
nodding
from.
the head because you argued that Tata.
Not only privy purses, some privileges.
Correct.
All states were divided into gun salute states. Some were 21 gun salute, somewhere the smallest was one gun salute.
They did refer to presidential orders in that merger agreements also. No. At that time, there won't be any president as such.
No, my lord, there was none.
No. Because at the time when the agreements were signed, there won't be a.
Thereafter, the constitution was made and the honorable president was elected.
The petitioner.
No, merger agreements were signed by Dominion of India or subsequently Government of India by the Secretary, Minister of State, Ministry of State. VP Menon, my lord, essentially is the signatory.
Four and 75 make a brief reference.
Yes.
Para 74 and 70.
Subscribe now and press the bell icon.